And I would ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call the 9:30 a.m. case.
Thank you, Your Honor. May it please the court. The 9:30 a.m. docket for Friday, November 3rd, 2023 consists of one case. Appeal number 125084, League of Women Voters of Kansas, Loud Light, Kansas Appleseed Center for Law and Justice, Inc., and the Topeka Independent Living Resource Center versus Scott Schwab in his official capacity as Kansas Secretary of State, and Kris Kobach in his official capacity as Kansas Attorney General. Appellees and petitioners have requested 3 minutes rebuttal time. Council will approach the lectern and enter their appearances.
May it please the court. I'm Kris Kobach, Attorney General. With me are Solicitor General Anthony Powell and Attorney Brad Schlossman.
May it please the court. My name is Elizabeth Frost. It's my great honor to be presenting argument today on behalf of the appellants, the League of Women Voters of Kansas, Loud Light, Kansas Appleseed, and the Topeka Independent Living Resource Center. With me are co-counsel Pedro Iriganagaire, Jason Zafadil, Dave Anstadt, and Marissa O'Gara.
Thank you. Thank you, counsel. Attorney General Kobach, you may begin.
May it please the court. This case concerns constitutional challenges to two Kansas election laws. One, KSA 25-1124H regulates advance voting by mail and requires the verification of the voter's signature on the outside of the ballot envelope to ensure that the vote is not being cast by someone else. The other, KSA 25-2437, prevents what is sometimes called ballot harvesting by limiting the number of ballots a third party may collect to 10 ballots. These two regulations are far more generous and liberal than those in other states, in particular the cure procedures, which go way beyond what other states provide. But I'd like to begin by making three general observations on which this case must turn. First, express caveats on the right to vote in our Kansas Constitution. Second, why the right to vote is categorically different than other constitutional rights. And third, the high hurdle for facial challenges like this one. So let me begin, as we must in every constitutional case, with a look at the constitutional text. The first observation that must be made is that unlike many other states, in Kansas, we have two express caveats on the right to vote found in our Constitution.
Well, before you get to the caveats, Mr. Kobach, you do acknowledge that our Kansas Constitution, at least in Section 5, talks and guarantees or protects the right to vote. Would you agree with that?
We agree that the Constitution does create a right to vote, Your Honor.
And shouldn't we be concerned once our Constitution protects that right to vote, acknowledges the right to vote, that we should do everything, you and everyone should do everything in their power to ensure that that exercise of the right to vote is not only allowed, but counted?
Your Honor, I think that's where it gets more nuanced, because then I think you have to jump to Article 5, Section 4, which is the first caveat. Quote, the legislature shall provide for proper proofs of the right of suffrage. A signature verification requirement is just such a proof. It ensures that you are the person who has the right to vote that ballot. And note that it says shall. The legislature shall provide for proper proofs. The Constitution mandates that the legislature has to pass laws that secure the voting process against people either being unqualified or voting, or people voting in someone else's stead.
Let me make a twist on that question. Once the state authorizes advanced voting, mail-in voting, whatever protections would attach to the counting of votes that are done the normal way at the polling place, wouldn't the same protections attach once the ballot has been cast as an advance mail ballot? See what I'm saying? I mean, once we give the voter the choice and the voter exercises that choice, and I can see the argument about some different hurdles to be able to exercise the choice. I'm not on the front end of that. I'm on the back end. Once the vote is cast, doesn't the state have the same obligation to ensure that both votes are counted appropriately?
I think, Your Honor, I wouldn't draw the dividing line as once the vote is cast, when the actual checking of the ballot occurs. In both processes, whether it be the in-person process or the voting by mail advance ballot process, there is a point at which the state ensures that this is indeed the person who is entitled to cast this person's vote. In voting in person, we do it before the vote is actually counted with the photo ID. You announce your name, you're supposed to say your address, you sign the book. In voting by mail, we do it after the ballot is filled out, and then when the ballot is received, that's when the election official verifies the signature to make sure that this does indeed appear to be.
And let me follow up on that. I have, let's say, I vote by mail or advanced ballot. I have done everything correctly at that point by filling out my ballot, either mailing it or giving it to a collector. I, as a voter, have exercised my right to vote. And why should there be hurdles in making my vote count? I mean, that's the point that seems, and aren't you interested in having people who have, in my shoes, who have exercised their right to vote in the appropriate legal manner, have it count?
Well, the only hurdle, I don't think it would necessarily be called a hurdle, but the hurdle is signing your name on the outside of the envelope, which has been required since at least the 1930s in Kansas. And for most of that time, the counties have been verifying your signature. With this statute and with the regulation that was promulgated after it, we simply made uniform that all counties would be doing this.
How is it uniform? It is uniform that all counties will look at the signature, but the means by which they ascertain its validity is not uniform. There's 105, I guess, different ways of doing it.
Well, actually, I would say that in the wake of the regulation promulgated in May of 2022, it is highly uniform. The regulation has cure mechanisms that are very generous, and they must be occur in every county in the state. So prior to this, the statute and the regs, you had some counties verifying the signature and some counties not verifying the signature. And the counties that did verify didn't have any uniform standards. Now, in the wake of the regulations, you have all kinds of things. You have the cure procedure. The official must call the voter at least 3 times after there's a perceived mismatch and must leave a message with detailed instructions if the voter doesn't answer. The official must also send a letter to the voter, giving the voter detailed instructions. In addition, the official may utilize email and personal visits to the voter's residence. The official must record the results of each contact. And once the voter is contacted, he's informed that he can send in a new try at the signature via mail or email. And on top of all those cure mechanisms, there's the standardization, which you were referring to, Justice Rosen, and that is the regulation requires every official who verifies the signatures to undergo uniform training provided by the Secretary of State. And that signature is compared to as many signatures as possible. It's not, as has been suggested in the briefing, a signature 20 years ago, and the person may have aged and have a different signature today. It's the signature 2 weeks ago that you gave to when you requested the absentee ballot. That one is immediately recorded into the system, and it's that very recent signature. And at least 2 officials who've both been trained have to both agree that the signatures are inconsistent in multiple significant or obvious respects.
What do we do with those regulations? We've got a room full of law students here, so let's talk about civil procedure. The regulations went into effect after the district court sustained your motion to dismiss. So I'm not sure how we take them into consideration now, but even if we want to take them into consideration, isn't that something that needs to be vetted through some kind of trial factual process rather than giving them credence?
Well, first of all, Your Honor, if you're suggesting that the factual process would be some sort of discovery about how the regulations were drafted, I don't think so. The law speaks for itself, and normally you wouldn't say that you can't.
Whether they're effective. I mean, you're trying to presume that these regulations somehow backfill some problems that they're suggesting. I'm just saying, isn't that a factual fight?
Oh, well, Your Honor, the process of drafting the regulations began immediately after the statute was passed in 2021. And it's really important to note that there's two precedents here that say that the regulations can and should be considered. This court said in State versus Obregon just 4 years ago, a party may seek and obtain the benefit of a change in the law during pendency of a direct appeal. This court also said the same in Tong versus Werholtz. That's cited in our supplemental brief at page 19. And the regulations, which are 736-9, have been in effect a full 18 months now. They were in effect during the 2022 elections. They were officially formally promulgated just before the briefing was concluded in the Court of Appeals. I think what it probably should have happened is that the Court of Appeals should have called for supplemental briefing about the new regulations, but all parties have been aware of them for 18 months, and the regulations now have been in effect and have been utilized in the election.
But going to the second part of what Justice Biles is saying, we're up here on a motion to dismiss, right? So we have to take everything that the plaintiffs say and, look at it in a light most favorable to them. And the standards that we're talking about, that every county, the standard for determining a match is entirely up to the counties. And we don't even know what kind of training people are getting, especially given that, the regulations talk about training, but it's a factual question about what kind of training. And you especially think about in a trial, when we are determining factual questions, we often bring in experts to analyze handwriting and determine whether a signature matches. And these all seem to me to be highly factual questions that shouldn't be determined on a motion to dismiss.
Well, Your Honor, on a motion to dismiss, though, the court can and should, especially in a facial challenge on a motion to dismiss, the court can and should assess the regulation on its face and the statute on its face and judge whether this is a severe burden on the right to vote, and then go to a two-track system, which I'd like to speak about in a moment. And those are legal decisions. Those aren't factual determinations. It's a legal decision to say whether this system will adequately protect the person in whose signature might mismatch on the first time. Just like the U.S. Supreme Court in Crawford considered the question of whether the burden of driving to the DMV, getting a photo ID that you didn't have, and then driving home and voting and using that photo ID. The court assessed that burden not as a matter of a factual discovery finding, but said in the abstract, that does not constitute a severe burden on the right to vote. This was the
Right, so that presupposes that we would be overturning the Court of Appeals decision not to use strict scrutiny.
Correct, that does. And I'd like to get to that if I
But if I could stop you before you move on, I think you just touched on a question that I had, which is maybe procedural. How much, to what extent do the factual allegations in the petition matter when we're examining the facial challenge, right? Are you suggesting then that that's just a completely separate analysis? It's a pure question of law. And even though this is coming to us under a motion to dismiss standard, the way that the claims have been framed sort of divorces those factual allegations from our analysis of the constitutional claims.
Yes, I think that's a fair way to characterize it, Your Honor. And again, this really goes to the question of whether you're going to use a two-track analysis like Anderson Burdick, or you're going to do what the plaintiffs are asking you to do and just say any regulation affecting voting automatically gets strict scrutiny. I think if they prevail on that question, then the facial challenge becomes a little bit different. And if I might just elaborate on that with the point I wanted to make regarding the Kansas Proofs Clause. That clause makes strict scrutiny highly inappropriate because under strict scrutiny, the law is presumed unconstitutional. But if the legislature has an obligation to pass that law, then we would be reading the Constitution to say that the legislature must pass a law which the judiciary will presume to be unconstitutional. Then on top of that, you also have Article 4, Section 1, which gives the legislature the authority to prescribe the mode of voting. It's a time, place, or manner clause. Again, the legislature, and there too, the legislature shall provide for these. So if we have a strict scrutiny all the time, on something that the legislature has an obligation to
Okay,
do.
can I just interrupt?
Yeah.
Why does the legislature have an obligation? Are you talking about Article 5, Section 4?
Yes, the legislature shall provide for proper proofs of the right
Okay,
of suffrage.
so I did have a question about that when you brought it up earlier. When you go back to when the Kansas Constitution was passed, originally they rejected that section. They rejected that section until a delegate explained that it was purely a registry provision, just solely authorizing the legislature to set up a registry. And it had to do with the 500 Missourians that came over and voted. We didn't have a registry back then. And so it was just about registering to vote, not about actually voting. So I'm not sure that I'm entirely persuaded that providing by law for proper proofs of the right to vote goes beyond anything beyond having a legislature set up a registry.
Well, Your Honor, good question. However, this court in Butts actually addressed what is a proof. And the court noted at least 4 different things that constitute a proof. Number 1, a requirement that the person be registered to cast a vote at least 10 days prior to the election. Number 2, a requirement that you register every single year in person at the city clerk's office. Number 3, and I think this one is a different one, a requirement that one must vote at a particular polling location. Why would they do that? They would do that because you're more likely to be able to ascertain that somebody is pretending to be someone else if you're voting in the vicinity.
What was the third one again?
A requirement that you must vote at a particular polling
Okay.
location and can't vote just anywhere you want to.
But doesn't that go to time, place, or manner?
I think these can all be characterized as time, place, and manner restrictions as well, Your Honor. Yes.
Well, time, place, and manner is an elections directive, and this is a vote.
Oh,
So
you're
tell me how you distinguish then between the elections directive of time, place, and manner and actually having exercised your right to vote, which is somewhere else in the Constitution, and then being in a post-vote situation.
Well, I think there's probably not a clear line that could be drawn because the proofs that Justice Standards was talking about, the proofs obviously go to the registration process, which some people, depending on the semantics of it, might say, well, that's not really time, place, or manner of voting, that's pre-voting. I would say time, place, or manner covers everything, the registration, the vote, and the handling of the ballot afterward. But I think trying to parse that, either way, it doesn't matter to what the Constitution says. The Constitution just says the legislature shall provide such proper proofs. And it also says that the legislature shall prescribe the mode of voting. So I don't think we have to categorize it as time, place, or manner or draw that line to come to a decision. But I would say
We don't do that if it's completely clear what it means. But if it's not, then we do look to the legislative history, don't we?
you certainly can look to it, but this court has already looked to it. And the other thing I would mention is that in 1859, universal U.S. Postal Service to the territory did not yet exist. Voting by mail did not exist in any of the states at that time. And so we're looking at a proofs clause that, like many of the clauses of our Constitution, we have to pull forward in time 150 years and say, what would be proofs today? And I think one would fairly say that verifying the signature would be a proof today, even if you do that.
And how have we historically analyzed whether a proper proof regulation is in fact pretext for an additional qualification on the right to vote?
Oh, that's a very good question, Your Honor. And this court has previously said that adding qualifications to the right to vote, like the court addressed this in great detail in, it was either, I'll come up with a case in a moment for you. But the court said that certain things that add qualifications, like having paid your taxes, the court was looking at a Missouri law at that time, or whether you reside outside of the city limits versus inside of the city limits, even though the election covered both. Those things do amount to qualifications. And this court has focused on laws that are outright disenfranchisement, where you disqualify people from voting, and has said those get the highest level of scrutiny, but routine, reasonable regulations do not. I want to go to my second observation, if I may, and I think this is an important one. The right to vote differs from other constitutional rights. plaintiffs ask you to view all constitutional rights as essentially the same. And from that mistaken premise, they leap to the conclusion that strict scrutiny always applies. But they are wrong on the premise. The right to vote is categorically distinct from other rights for two reasons. First, the right to vote is not properly characterized as a liberty or an expression of individual autonomy. If any of us wishes to exercise our freedom of speech, we may do so whenever we choose. If we wish to worship, we may do so whenever we choose. We have absolute autonomy, and we really don't rely on anyone or any entity for us to do that. But the same cannot be said of voting. We can only exercise the right to vote on one of the 40 days each year when the state of Kansas is holding an election. And we can only exercise that right in the forum that the state has created. Indeed, without the government's help, we can't even begin to exercise our right to vote. And so therefore, you cannot say that this is an exercise of personal autonomy. And indeed, it's not even a liberty as that word is traditionally defined, which is freedom from external restraint, especially by government. Second, in contrast to other rights, we do not hold the right to vote against the government. Most rights are held against the government. We forbid the government from interfering in our exercise of the right, as in Congress shall make no law abridging our freedom of speech, the freedom of speech. Or stated differently, a constitutional right in most cases imposes a duty on the government not to act. But the right to vote requires the government to act and to act extensively, to create a forum and to cooperate with the right holders in the exercise of their right. It is categorically different, and that's why it cannot be treated in cookie cutter fashion as the plaintiffs would do, as the same as freedom of speech, same as freedom of worship, or even the same as the abortion right that this court recognized in Hodes, or any other normal liberty-based right.
Attorney General, you've gone well beyond your time. I've allowed that. And if there are any other questions, we'll ask them, and I'll give you a minute to kind of wrap up or a short wrap
Well,
up.
just briefly, one of the aspects that troubles me is the posture of the case in two ways. But first, it's here on a motion to dismiss. I mean, that's what the district court did, and apparently, as I read it, either kind of applied either rational basis or the Anderson verdict test. And I just don't understand how the Anderson verdict test can be applied without some sort of factual development. There was none at the district court. I mean, just the Anderson verdict test requires some sort of establishment of burden and comparing that. And that is completely absent from what's before us. Why didn't that take at least some factual development at the district court if we even adopt that standard?
Your Honor, I would say that most appellate courts in applying the Anderson verdict test have done so in many cases without extensive discovery, because if they're going to hold that it is of the lesser track of the two tracks of scrutiny, because if it's not a severe burden on one's voting rights, and that can be assessed as a question of law without actual facts specific to the plaintiffs, then you can go ahead and proceed to the lower track, which is a mere rational basis, looking at, is the text of this law reasonable and rational? The second point is that this is a facial challenge. And I think this is an incredibly important thing here in this case. As this court said in Bollinger, facial challenges are disfavored because they may rest on speculation, may be contrary to the fundamental principles of judicial restraint, and may threaten to undermine the democratic process. And then this court in State v. Jones explained exactly what the burden is in a facial challenge. And I want to quote that. A facial challenge to the constitutionality of legislation is the most difficult challenge to mount successfully, since the challenger must establish that no set of circumstances exists under which the act would be valid. End quote. No set of circumstances exists. Plaintiffs simply can't meet this standard. The public record cited in our briefs makes this clear. Of the 135,832 mail ballots cast in the 2022 general election, there were only 105 rejected based on signature mismatch. That's less than 0.08% So there are at least 135,727 circumstances in which the statute operated and did not conceivably interfere with anyone's constitutional right. And in the other 105 cases, it is likely that no rights were violated there too.
But let me ask you a question about that, because that case was based on the Supreme Court's decision in Salerno. And how do you square that with the Supreme Court's later decision in Patel, which says the proper focus which criticizes Salerno and says the proper focus of the constitutional inquiry is the group for whom the law is a restriction, not the group for whom the law is irrelevant.
I don't think that changes the analysis for this case, because the group that they are alleging for which this is a restriction is essentially anyone. They're claiming that the signature verification rule is inherently
No, I think they're saying
non-standard.
in Patel, it would be the 105 people. So, right?
Well,
Under Patel, it would be the group for whom the law is a restriction, not the group for whom the law is irrelevant.
right, but the group is not defined beforehand as people who meet some characteristic or people who vote in this way or people who do this or that. And so I don't think we would just throw out the facial challenge and say, well, really, it's just like any other challenge. I think it's important to note here, the plaintiff's attorneys could have waited for the 2022 election to occur, looked at those 105 cases, examined the facts, and if they found specific cases supporting their claims, brought an as-applied challenge to this court, and the bar would be very different. But they did not do so. And so the facial challenge bar is the one that applies, and it is very high. And because it's a facial challenge, Justice Rosen, I think that makes the need to go to the district court and look for specific facts less important. We just look at the statute on its face, and we ask, on its face, does this statute violate the right to vote? And we ask that in the context of looking at the other clauses in the Kansas Constitution, which place caveats on that. And we look at that with the knowledge that the right to vote is categorically distinct from other rights. And there will always have to be some regulations which are designed to protect the voter, to ensure that when you sign your name, someone will try to make sure that that signature is you. I think most voters throughout the history of our signature requirements, which again, go back to the 1930s, all of us just assumed that somebody was going to check and make sure that it's me, because really with advanced voting by mail, that's the only way we have to have any confidence at all that this is the person who is casting the vote.
And this might be a little backwards, probably should have addressed this initially, but do you agree with the Court of Appeals that we have jurisdiction to hear this matter? We here are very concerned about piecemeal appeals.
Yes.
and fractured cases and the consequences of that. And this probably defines the piecemeal appeal, with one case taking two different tracks with two different panels on the Court of Appeals that is awaiting our decision on that. And what we may do with that requires further work. And just tell me what you think about what the posture of this case is and what it should be.
Your Honor, we concede this is a close question because you have the statute 60-2102A3,
right,
and that suggests that this appeal would be proper. On the other hand, you have the abundant case law from this court requiring a semblance of finality before the case comes to the court. And we address this in full on pages 4 to 10 of our brief to the Court of Appeals. But to concisely answer your question,
but the Court of Appeals rejected that essentially, and
yes,
then you didn't really, in your petition, really object to that. But I'm just.
Well, for space constraints, we felt with the previous brief could suffice to explain that. But
Well,
the answer is this. The reason there is technically no finality after the district court issued a motion to dismiss in this case is because that third claim, which is moving on a separate track concerning false representation of an election official, was divested from the other two and came all the way up to this court, but it's still on a temporary injunction phase.
Right.
So it's going to go all the way back down to the district court for a decision on the case in chief. And so technically, this case isn't going to be final until the district court rules on that. Now, the way the Court of Appeals got around it is saying, well, effectively, these two cases have been separated into different cases. They're not really the same anymore. And I think that's where this court's going to have to give us some guidance. Is that effective separation enough to say that this case had a final judgment? Or do we look literally at the cases and say, technically, they're still the same case? And so I think that's, in whichever direction you go, it's going to have ramifications beyond this case. I think it'll have ramification for prisoner appeals. And I think this court, is going to have to wrestle with that one. And I don't think there's an easy answer. But to jurisdiction, I do think there is a much clearer jurisdictional answer with respect to standing, which we briefed at pages 11 through 22 of our brief to the court below. Only one organization here, the League of Women Voters, have any members that can qualify under the indicia of membership test that this court has used. And even in looking at that one membership, all of the members there lack the imminence to their injury.
The Court of Appeals in their decision did a pretty lengthy analysis of your standing argument and rejected it. And again, and I know this court independently takes up issues of jurisdiction and standing, but you didn't oppose that conclusion of the Court of Appeals in your petition.
Well, and we again, because of space constraints, there's so much on the merits to brief here that we didn't rebrief it, but we assumed that the court would assess its own jurisdiction at each phase. I think the speculative nature should be highlighted, though. In addition to the imminence problem, all of the injuries are purely speculative. And if you look at the organizational standing claim, they don't even in their initial pleadings explain how the diversion of resources is going to occur. And that is their one link for organizational standing, is that somehow they're going to divert resources. Well, they were already telling voters how to vote by mail. If they're adding a sentence at the bottom of the page saying, oh, and if you think your vote might not count, you can have someone sign for you on the envelope, you won't have to sign, or you can just, after the week after the election, make sure you check your voicemail. I don't think that diverts any resources. So
what about the collecting ballots on the organizational standing?
There too, it's unclear how that would divert resources either. The organization doesn't have to.
Well, they say if you could only collect 10 ballots, that they would, if they were usually collecting 50, they would have to recruit 5 times as many volunteers.
I think in that instance, Your Honor, though, that's a choice, a burden that the organization willingly imposes upon itself when they don't have to.
Well, it's just that's their mission, is to.
Right. No, I think if one could certainly, giving them all benefit of the doubt, say, well, if they believe they just have to have someone standing by for every single person who conceivably wants to have a ballot collector rather than use the Postal Service, then that argument knows no limits. There would always be more ballot collectors for them to recruit. But as a practical matter, the U.S. Supreme Court noted this in the Brnovich case. There are so many other ways to deliver that ballot. You can hand the ballot, you can put a stamp on it and put it in the mailbox. You can drive the ballot or have somebody else, your relative. It doesn't have to be a collector, a third-person collector. You can have a relative or a friend drop it by the election office early.
Well, right, but if it's a relative, the relative can only do 10.
Correct. The relative can only do 10. And indeed, the much more restrictive Arizona law, which said it has to be a relative or a caretaker, nobody else. That was upheld by the U.S. Supreme Court using exactly this kind of analysis, saying, look, you have so many other ways of doing it. Even on its face, this statute doesn't impose a burden on the person, a significant burden. In addition, the Minnesota Supreme Court in Simon looked at a statute where you could only have 3. Only 3. No ballot collector could take more than 3. That was a far more restrictive
And
standard.
were those analyzed under the federal constitution or the state constitution?
I believe, I'm not certain on the Simon case. The Brnovich was federal. Simon, I think, was a combination of Minnesota Supreme Court, Minnesota Constitution and federal. But the court there did apply a 2-track test and said that this is a minimal burden. The fact that you might have someone who's already collected 3 and you'd have to look for somebody else or just deliver it yourself. Court said minimal burden and denied the challenge.
Are there other questions? Okay, thank you
Thank you.
for your.
May it please the court, Elizabeth Frost on behalf of the appellants. With the court's indulgence, I'll begin with the proper proofs question and this court's decision in Butts. Butts held that even under the cloak of proper proofs, the legislature can't effectively impose additional qualifications. At issue in that case was a voter registration system that the court stressed over and over again was incredibly open, looking at all the circumstances. With the signature verification requirement, here the voter has registered, they've produced those proper proofs, they've requested an absentee ballot, and it applies essentially a consistent handwriting qualifications test. The ballot collection restriction has nothing to do with proper proofs at all. In fact, I don't think I heard the Attorney General say anything about how that could possibly fit under that rubric. Here, the plaintiffs alleged on a credible facts that both of these restrictions impede on the right to vote of lawful, qualified voters who have done everything right. And this is where this court emphasized in Hodes that it is so important under those circumstances when there has been a credible showing of burden or infringement on a fundamental right, that the state have to show that the rule actually advances what they're claiming to do. Our allegations are that signature matching by inexperts under these standards is worse than flipping a coin. As Justice Standridge pointed out, courts bring in experts to match signatures. In its papers, the state complains that we are demanding a forensic standard, but you know what? That's what we demand of voting machines. There's also no right to cast your ballot on an electronic voting machine in the Kansas Constitution, but we don't allow inexperts to fiddle with it. In fact, for those kinds of things, we're very careful that those machines are not inadvertently rejecting ballots. And what has happened in Arizona, since the Attorney General mentioned in Arizona, after 2020, when the same kinds of lies about voter fraud that led to these laws led to a audit by an inexpert group called the Cyber Ninjas, they had to take all of those machines out of commission because an inexpert had touched them, and it cost the state millions of dollars. The 10 ballot limit, as I mentioned, is obviously not a proper proof. And the affidavit itself which has been, a portion of the affidavit has been in place for 10 years. We don't challenge either the old affidavit or the new affidavit, which has the voter countersign that yes, they're giving this ballot to this ballot collector. Yes, this ballot collector hasn't imposed any undue influence on me in casting my ballot. Yes, they can take it. In Kansas, by the way, you can track your ballot and see where it went. It simply isn't true that either you need the signature verification or the 10 ballot limit, which again, no one has ever explained, in order to secure elections. In fact, Kansas has been securing elections just fine. There was an intensive audit, and the Secretary of State said it was the most secure election in Kansas's history in 2020. There's all kinds of safeguards that the Secretary of State's office, that Kansas law impose on advanced ballot voting, including you have to request a ballot. So if I wanted to request a ballot, for example, in my co-counsel's name, I'd have to know a lot about him to get it. I'd have to be pretty confident he's not going to request his own ballot or show up at the polls and try and vote it.
Ms. Frost, let's say we adopt your position of strict scrutiny. Where I'm having a challenge here is how is it that we decide whatever law or regulation impairs the right to vote? I mean, right now there exists many laws on the books in the state of Kansas that could fit your argument that impairs the right to vote. The polls open at 7 in the morning and close at 7 in the evening. What about someone who works a double shift? Is his right to vote being impaired? How does that line get drawn? And I think that's especially challenging because the Constitution recognizes the right to vote, but also recognizes the legislature's ability to regulate time, place, and manner. And to me, that's a real challenge here if we adopt your point of view.
So it's an excellent question, Justice Rosen, and I think the answer is actually in Butts. What Butts does is it acknowledges that sometimes, despite the fact that this was a very permissive registration system, I'll remind you that it closed the books only 10 days before the election. You could register all over the state. There was no evidence in that case that it was systemically impeding anyone's ability to vote or have their ballot counted. But the court noted that, yeah, every once in a while, there'll be a sick voter or a voter, who, because of some unexpected situation, won't be able to vote. And I think what Butts tells you is you ask first, either on the face of the law or based on credible allegations, it doesn't indicate that there are burdens that are going to be imposed systemically on voters in the normal course outside of those sort of isolated one-off unexpected incidents. And then as a practical matter, and I think it's important to focus on as a practical matter, what this test means. Then you ask 3 questions when you move into strict scrutiny of the state. Number 1, is there actual, not fanciful issues that the law addresses? For example, is there a true threat to election integrity that we need to be worried about? Second, is the law actually helpful to address this issue? And this is something this court stressed in Hodes was incredibly important. And I think that is phenomenally important when you're talking about legislators making decisions about whose ballots will count or which voters can enter the process by which means. If you're showing a burden, a systemic burden, then I think the legislature, it's not too much to ask the legislature, is this law actually advancing the interest that you say it's advancing? And then third, does it do it in a way that is rights focused? Are we focusing on making sure that as many lawful voters can vote and only impeding those that we have to because of this situation? And this is not something unusual. That is not outside the abilities of the legislature. The legislature does this all the time. And in fact, I was struck when I was reading this court's decision in Liggett, which involved the requirement of med-mal insurance for doctors, that even though in that case, because no fundamental right was an issue, it was not under heightened scrutiny, the descriptive of the legislative process that law went through was, I think, very telling. They excluded dentists because it turned out after they listened to everyone who showed up, dentists didn't have the same kind of problem that doctors had in this healthcare crisis. They found they had a lot of evidence there actually was a healthcare crisis being involved. They tailored this thing. They didn't have to, but my point is that this is what legislators do every day. Then you compare it to what happened with these laws, which involve the fundamental right to vote. And the signature verification requirement came in an amendment in the House, I believe, so it was never seen by the Senate at all. The ballot collection restriction was introduced for the whole time in the Committee of the Whole, even though there was hardly any opportunity for anyone to talk about either of these laws. Legislators, witnesses, the legislature still had so many red flags and alarm bells that these would make it harder for lawful voters to vote. Even legislators who voted for these laws expressed concerns. Senator Dietrich noted she was hesitant about the signature verification requirement because the county election officials hadn't even had an opportunity to weigh in on this. Senator Hildebrand recognized that his signature 5 years ago was totally different. On the ballot collection restriction, Senator Ware, who voted against it, kept asking, why are we turning helpful neighbors with 10 ballots into criminals with the 11th ballot? What are we solving? No one was ever able to give her an answer. So this is not some radical decision by any means. And I have a lot of confidence that while there may be some laws here and there, most of Kansas's election laws would pass this just fine. Frankly, I think in a lot of cases, the plaintiff would have a hard time getting over the first part.
Along those lines, could the legislature just repeal or take away the advanced ballot measure that's passed that allows this to happen in the first place?
So I think that's a question, obviously, that would have to be determined on its facts. And that's where I say, I think you have to look at what is the impact on voters. I'd also point out, and this is obviously not the issue before the court, so take it as you will. But Kansas has an unusually long history of advanced voting. It goes back to the Civil War. In 1971, Kansas actually amended its qualifications clause to refer to absentee voting. I recognize that it refers specifically to the right to vote in person and absentee of voters who've moved away. But certainly in the same way that there's no explicit right to specific ways to vote in the Constitution. The question is, looking at the circumstances, is it going to impede voters' ability to vote or have their lawful ballots counted? And I think that's a matter of proof. I would also add that Kansas is not even really flirted with the idea of taking away advance voting.
No, I understand, but it's kind of that time, place and manner where it fits. And it seems to me that's what it is.
Yeah, although I would also say that I think a lot has changed. You know, you have to look at the practical nature of how people vote and how people interact. And as a lot has changed, obviously, since Butts was decided. I mean, one of the things that Butts stresses over and over is at the time, persons who'd been naturalized had to produce their naturalization certificate. Obviously, a federal court found that that was unconstitutional in Fish v. Kobach. So I think you have to look at the evidence in front of you. There are certain cases that are going to be more obvious than others. These particular ones are simply not in the gray.
Counsel, how do you address the exacting standard of a facial challenge that we heard your opposing counsel highlight and point out, where, at least as I understand the argument, that the factual allegations maybe can be divorced from the legal standard that sort of frames all of the constitutional claims?
So first of all, I would say that the federal courts don't look at restrictions on the right to vote that way. So I think if one were to accept the state's view that whenever there's a facial challenge to an election law before it's been implemented, that you could only look at the pure text of the law, Kansas would be an outlier, applying an even stricter bar on plaintiffs entering the courthouse doors on impingements on the right to vote, even further than the federal standard.
So pre-implementation challenges at the federal level how have they approached it then in those situations?
So similar to the kind of evidence that has been presented in support of the motion for a temporary injunction, where you look at the characteristics of the voters who are likely to be impacted, you introduce evidence to show the problems that they will have to overcome, if they could overcome them at all, to have their ballots counted. That's the way the courts have handled that. And of course, this court has found that the presumption is reversed when a fundamental right is infringed. And the other point I would make is that the federal courts have also emphasized, in fact, the 10th Circuit, and I apologize, I can't remember the name of the case in this moment, but that even under the strict standard the state argues for, the courts can't come up with hypothetical situations in which these things would be valid. So I think it is important to take a step back and remember the state is saying we need these things to protect against fraud. Our allegations are that if these things catch fraud, it's a total accident. So in this situation, the hypothetical application of the law is when it catches the bad guys. So I think even in this situation, that standard actually favors the plaintiffs.
Counsel, if I could, I'd like to explore with you a little bit the nature of the right at issue. And I think throughout this case, and even here this morning, it's described as a fundamental right. And I don't mean to suggest it's not necessarily that, but that language, fundamental right, really arises out of modern due process case law. And if you go back to this court's decision in Hodes and look at Section 1, even as the majority in Hodes acknowledged, what was being dealt with there was what our founders going all the way back in legal philosophy to Locke would have described as a natural right. And that's as distinct from a political right. I think highly summarized the natural right. Natural rights are those that pre-exist government, and political rights are those that come into existence with the advent of government. So I want you to talk a little bit about where the right to vote falls on that continuum.
Absolutely, Justice Stegall. So I think that the fundamental right to vote is obviously explicit in Article 5, Section 1, right? These people shall be able to vote.
That would suggest that it's a political right, wouldn't it?
It would suggest that it's a political right. And
sorry to interrupt, but just where I want you to zero in on in my question is, if it's a political right, which is expressly guaranteed in Section 5, that would suggest at least that it is not a natural right and that we would not look to Section 1.
Your Honor, I think the question of whether you look to section 1, you probably don't even have to. I think it's probably still a little bit in flux.
Well, if we didn't look to section 1, I think you would lose a large chunk of the case law that you rely on to get to strict scrutiny. You may still be able to get to strict scrutiny under a different path, but that's not the path that this case has been litigated. Would you
Okay.
at least agree with me on that?
No, let me walk you down this path, because I think that that over the past, say, 140 years, this court has said a lot of things about the Bill of Rights generally. It has then said things about section 1 of the Bill of Rights. It has said other things about section 2 of the Bill of Rights. And I think that some of the case law we rely upon to get to strict scrutiny is found in cases that talk about the Bill of Rights in general, and how you have to say that each word has to have some meaning. It's not just a glittering generality. I want to focus in on the political right, because as I know, Your Honor wrote about this in Rivera, and Rivera was obviously a very different case where the issue there, as this court explained, sounded in equal protection because it had to do with vote dilution rather than sort of hurdles to the right to vote itself. So it didn't look to Article 5, Section 1. But if you go back, this court has said at least twice in State ex rel Fatser and then in Herkin v. Glenn that a political right includes the right to exercise the right of suffrage. And Rivera did not talk so much about the political rights language in this way because it didn't have to, because it wasn't about the exercise of the right to suffrage. So I would actually submit that the plain language of Bill of Rights with the political right and the right to suffrage is very clear limitations based on, if you work through Atchison, Winters, all the way on up.
Yeah, and again, I appreciate the thorough answer. That's actually quite helpful. Correct me if I'm wrong. It sounds like your argument is essentially, yes, it's a political right, and our case law is pretty uniform and is still applying a strict scrutiny type test to impingements on those political rights.
On political rights, differentiating, because I recognize Rivera, rights that really sound in equal protection, even if they are described in a different way.
And do those derive from section 1 or do they derive from section 2 and section 5?
So they explicitly derive, I think, they are explicitly found in section 2 and Article 5, section 1. I think that this court's case law is honestly still trying to come to grounds with exactly the expanse of section 1. And so I think when the court has talked about fundamental rights, it has often talked about the Bill of Rights in general, and has looked at these. And I think one of the things that's actually quite interesting, right, is if you look at this court's recent decisions about section 5 of the Bill of Rights, for example, if we accept the state's argument, then the right to civil remedies or to expansive civil remedies in a trial is actually going to be more strongly protected than the right to vote, despite the fact that to get there, the court, had to look at a series of historical statements and cases, and yet the right to vote shows up in explicitly in 2 places in the Kansas Constitution. So it's hard to envision how we get that result given the textual differences in the Kansas Constitution.
Are there other questions? Give you a minute to wrap up.
Oh, would you touch on the jurisdictional question I asked Mr. Kobach?
Yeah, I honestly was a little confused by the Attorney General's answer, given that they argued that this court has jurisdiction. So we obviously believe if the question was, in fact, the question that I believe the Attorney General answered, which was, did the Court of Appeals have jurisdiction? We believe that that's the only sort of explanation for what that rule about constitutional questions that are final could apply in this particular situation. The district court judge was very clear that she was done with these questions. She would have reached the 3rd one, but for the fact that she couldn't because it was on its way up to this bench. So we believe the Court of Appeals had jurisdiction. As we noted when we opposed the petition for review, our interest has always been in expediting this case. Our interest has always been in getting this resolved for the voters so that, say, in the presidential preference primary in March, they're not facing these obstacles. And so our hope at that time was, given the timing, to get back down to the district court to get some kind of a resolution that we could use to protect the voters. But of course, as we acknowledge there, this court has discretion to take the state's appeal. And we think having taken it, it should be decided. Thank you very much.
Thank you.
May it please the court, I'd like to briefly respond to 3 points just brought up. One of the first points from opposing counsel is the contention that signature matching must be done by a forensic examiner or a trained expert. May it please the court, signature verification does not require a degree. In fact, there is no such thing as a degree in signature matching. On the contrary, it can be taught to laymen in a day or two, showing the typical procedures that are used for matching signatures. But if this court were to hold that signature matching in the election context can only be done by a forensic expert, that would upend multiple processes in the Kansas voting arena. Verifying petition signatures at the Secretary of State's office. County canvasses after the election routinely involve some signature verification. Applications to receive the advance ballot in the first place requires signature verifications. All of those processes would then require professionals, and it's not clear how any of those processes could occur. But I would also note that the Sixth Circuit addressed this issue in Husted and said arguable differences in how election boards apply uniform statewide standards to innumerable permutations of ballot regulations are to be expected, just as judges in sentencing guideline cases apply uniform standards with arguably different results. And this exact argument was rejected not only in the Sixth Circuit, but also in the Fifth and Ninth Circuit, where, as the Ninth Circuit said, uniform standards can produce different results. So true, it is possible that when you give people uniform standards and when you give trained forensic experts uniform standards, they might reach a different conclusion. But that doesn't mean that you throw out the entire system and you abandon signature matching entirely, because the entire reason we have signatures on these envelopes is to protect the voter from having someone else vote in his stead. The other argument I would like to address is their point that strict scrutiny absolutely has to apply to every voting regulation. I think Justice Rosen started to touch on this in a question he asked, and that is, look, if that were the case, then virtually every voter regulation would probably be struck down. As the Supreme Court said in Brnovich, every voting regulation imposes a burden of some sort. Look at our 7 o'clock closing time for elections. Is that the least restrictive means? No, it's not. 8 o'clock is less restrictive. 9 o'clock is even less restrictive. What if the legislature changes the advance voting period from 20 days to 14 days? Is that the least restrictive means? Certainly not. Every number above 14 is less restrictive than 14 days. Every one of these regulations lands somewhere on a spectrum, and there will always be some people who are burdened somewhat by that. And this court for the past 128 years has effectively been using a two-track approach. And I think we should highlight a couple of those cases. It began with Taylor versus Bleakley in 1895, where the court said the following: the legislature within the terms of the Constitution may adopt such reasonable regulations and restrictions for the exercise of the elective franchise as may be deemed necessary to prevent intimidation, bribery, and fraud. Then go to State v. Doan in 1916. This court started with that same deference to the legislature, but the Doan court identified where you would have a higher standard. And the Doan court said that occurs in outright disenfranchisement and struck down a law prohibiting certain electors from voting in superintendent elections. And that's where the Doan court also identified the Missouri payment of taxes requirement as disenfranchising people. And Doan also said a property ownership qualification would be outright disenfranchisement. So this court started going to a two-standard review in Bleakley and then Doan. Then in Lemons versus Noller in 1936, the court again applied the reasonableness standard to the Absentee Voters Act of 1919 and said the fact that some voters under some circumstances may be able to vote while others cannot does not make the statute invalid. And that situation, that description is far from what we have here. Then look to Sawyer v. Chapman, the most recent in 1986. Again, the court deferred to the legislature, holding how the secrecy is preserved as a matter for legislative determination. But here's the Sawyer quote I want to come to. The Sawyer touched on signature verification. And in Sawyer, at pages 413 and 414, this court noted that, quote, county election officials are required to verify the signature on the return envelope with the signature on the elector's registration records, end quote. And then said, it must be conceded that voting by mail increases the opportunity for fraud, end quote. That second one was on page 414.
But both in Lemons and Sawyer, those were both instances that granted greater access to voting, correct?
Correct. However, in Lemons, the court did note that with this advent of the absentee voting as conceived in that act, there would be some people who arguably might not be able to take advantage of it and others who could. So the court was looking at differences in ease of ability to gain access to that type of voting, which gets us back to strict scrutiny. Is that something that Kansas should do? I would say emphatically no. Not a single state in the country has adopted strict scrutiny for every voting rule. Kansas would be an aberration if we did so. And we have looked at every Court of Appeals opinion, mentioning the 5th, 6th, and 9th circuits, as well as the Supreme Court's Minnesota being the most direct on ballot collection restrictions. No state Supreme Court has said that every voting restriction must be evaluated under strict scrutiny. And when you add the Kansas proper proofs clause of Article 5, Section 4, it makes it even more imperative that this state not become the aberration on this subject.
But two things with that, those are federal appeals court applying the Anderson verdict test under the federal constitution, right? And then for the other states that have the Supreme Court, those are what you're specifically saying is every single election law, right? So you're including in that every single election law.
I'm saying that the standard the opposing
Right.
party is
Okay.
seeking is every single election law. But the point about looking at the Kansas statutes is we have effectively been applying an Anderson verdict test before Mr. Anderson or Mr. Burdick were ever born. For the past 128 years, this court has been applying a 2-track test. Reasonable, commonplace, normal restrictions to secure the vote are viewed under a rational basis, highly deferential standard, but outright disenfranchisement, like in Doan, that is viewed at something entirely different, where you take a category of voters and say, you can't vote. People who didn't pay their taxes, people who live outside of the city limits. Those are ones where strict scrutiny applies. And that is effectively
Is that strict scrutiny?
Well, they didn't use the term strict scrutiny.
They didn't
back
use the
in
term.
1916.
And for example, would a voting age restriction pass strict scrutiny?
Well, now the Constitution of Kansas, recognizes the right to vote people 18 and over. I would say a voting age restriction would probably, if the legislature put on the ballot and it passed an amendment to that, then of course it would be constitutionally valid under the Kansas Constitution, but you could argue that under the United States Constitution, strict scrutiny should be applied. Where you're taking an entire category of voters and saying you can no longer vote, I think
You're willing to concede? strict
I am
scrutiny?
absolutely willing to
Okay.
concede strict scrutiny in those cases. Yes. Well,
Can
Your
I
Honor,
hear you? One final question. If you could respond to your opposing counsel as to why signature verification is in fact a proof. In other words, why is it a proof under Article 5, Section 4 that validates one of the several qualifications to the right to vote in Article 5, Section 1?
I would argue, Your Honor, that the court in Butts is probably the best reference point we start with in what a proof is. And the court went to things well beyond simply the requirement that you register beforehand, which of course is relevant to the famous 1855 election of March of that year when the Missourians came in and twice as many votes were cast as actual people electors who resided in Kansas. But there's more to it than just registration, because then the court went on and said, well, where you are allowed to cast your vote is also a proof. Now, if you see proofs as merely proving you are qualified, that goes way beyond that. And so this court acknowledges that proofs go beyond just proving that you are qualified. They go to things that secure the election against fraud, and proving who you are, who you say you are, clearly is one of the most essential proofs that the legislature would demand. So for all of
I do have one question. When Justice Stegall said, if there was an age restriction and the Kansas the people of Kansas changed the Constitution and said you have to be 21 to vote. And you said whether that would violate the federal Constitution, that would be subject to strict scrutiny, right?
Yes.
But what about the Anderson-Burdick test? You're saying that the Anderson-Burdick test, because it is a flexible test, that's when the strict scrutiny would apply under Anderson-Burdick?
The Anderson-Burdick test says that, reasonable non-discriminatory restrictions, quoting the case, are generally deemed sufficient. But then the Anderson-Burdick test goes on to say, if you have truly severe burdens on one's ability to vote, and outright disqualification is clearly the most severe burden, then strict scrutiny applies. So Anderson-Burdick does allow for strict scrutiny
Okay.
on the second
That's
tier.
what I wanted.
So just let me follow up then. So there is a clear disenfranchisement of 17-year-olds in Kansas. Are you
Yeah, well,
suggesting that if,
that assumes that, yes, they are disenfranchised.
right.
I mean, they don't
by
have
law.
the right to vote in the first place.
right? So if, if a lawsuit gets filed in federal district court, you're suggesting the state would have to defend on strict scrutiny grounds? And would the state, I know I'm asking you a big hypothetical, but
Interesting hypothetical. I think we would argue that those individuals don't possess the right to vote in the first place. And so they aren't really being disenfranchised of something.
well, that is exactly what disenfranchisement is it
Yes,
not?
That's true. But we would argue that the right to vote, by its very essence, begins where a person has the cognitive ability.
We might have to go back to the foundational ideas about what a political right actually is.
We'd be going back to Locke for sure.
As opposed to a natural right, which would attach at
Again,
at
yeah.
a much younger age.
A very good period on the sentence. This gets back to our distinction. This is not a natural right. It's not a liberty as that term is traditionally defined. It's not a personal autonomy right. It is a right that requires government involvement and requires government cooperation and requires the government to set up the rules for exercising that right. Thank you, Your Honor. I appreciate it.
Thank you to both counsel for your arguments this morning. We will take this matter under advisement.